Bismillah ar-Rahman ar-Rahim. Assalamu alaikum and very good afternoon. Thank you, Prof. Logan and Bashir, and the members of the floor, distinguished audience. It gave me great pleasure to say a few words in this distinguished gathering of lawyers, intelligentsia, intellectual practitioners in this auspicious session. And that made me more nervous because talking to people of credential in 15-20 minutes would be very challenging. So I try to cut it short so that the nerves will disappear halfway through. I'm supposed to speak on something to do with Islamic law and how that relates, or how does that relate to contemporary finance as we are witnessing and observing and perhaps putting the regulation to govern, to improve and to protect the interests of all stakeholders coming to this industry. Okay. So again, from a jurisprudential point of view, I hope it is not something which is boring and classic. It is something to refresh our understanding, because some of you have studied Islamic law, some of you have not, but you have read and perhaps listened to many presentations. I'm a scholar of Islamic law. I did my Sharia degree and PhD in Islamic law, but also I did LLB on my own to complement the legal knowledge of Sharia and the legal practice. So as you know, Islam starts from day one, start from revelation, from wahyu in Arabic term. The Prophet Muhammad, peace be upon him, was revealed. So he was basically receiving the messages direct from the sky. So this is something unique about Islam and also Judaism and Christianity, because these are the revealed religion. And when Islam was revealed to the Prophet Muhammad as the last prophet to the whole world, the principle of revelation are contained in two sources, as you know: the Quran, the very word of Allah, in Arabic, somehow to be understood by the people. It was revealed in Arabic, it was revealed in other languages before Quran. Also in the practices and the statement and approval of the Prophet Muhammad, what we call the tradition of the Prophet Muhammad. Of course, as a human being, he died, he passed away, but the duty of interpretation, the duty of developing the law, supposed to be continued by his companion and the successors and the successors, and that what we call the interpretation aspect of law, guided by the revelation, by the sources of law which are divine. The Islamic law has developed throughout history through reasoning or through interpretation, through whatever we exercise in the court of the law when we put our argument to the lordship for him to consider with all the, ratio decidendi, the obiter dicta, and what have you in the legal tradition. So the same processes took place in Islamic literature, but, very important, but guided all the time by the sources which are divine, which are not human, in terms of origin, in terms of proposition, in terms of giving what is the parameters of everything: criminal law, commercial, personal conduct, family law, and so on and so forth. So in the history, the law was developed through three practitioners. I call them practitioners: the jurists, so-called the scholars. Like in civil law, for example, we have professors of law. They write the textbook. The textbook becomes the primary source of law in the civil law in European continent countries. We have also the muftis, what they call the jurisconsult, those who give the resolution based on the actual case presented to them. And not to mention the judges who resided and who listened and who, pass the judgment based on the trial before him. Of course, Islamic law, as you know, is not, they call it, it's not adversarial. It is very much inquisitive kind of justice administration, very much different from the common law and perhaps civil law, when it is more of adversarial Islamic law is more of an inquisitive way of finding the truth in any disputed case. So if I may conclude for the first slide, Islamic law was neither a case law nor a statute law. It is best described as divine law. It is best described as divine law, but developed by Islamic law specialists. Though it has some similarities to common law and the civil law in one way or another, which I'm going to explain in the next slide. So in the making of Islamic law, both case law and statute law approaches were used, but from historical, this is the current one, from the historical perspective, Islamic law specialists, the jurists, the scholars, the fuqaha and the mufti and the judges, the hukam, they have interpreted the law based on the principle. So Islamic law has been very much principle-based law, and the principles are derived directly from the two sources which are divine in character, cover to cover. And we cannot call that we are common law or common law because we have not developed what common law has developed, the law report, which is very much valuable in terms of lawmaking, because judicial precedent or stare decisis is part, perhaps the cardinal principle of English common law, for that matter. And in the civil law, judicial precedent is not that important. What is more important is the jurists, the understanding of the jurists, the professors, the scholars of the law who give the point of view with regard to certain law. In Sharia, to conclude, there are principles given. The scholar came to the principle and tried to understand the principle based on the current requirement of the day, the practices of the society, the justice, and so on and so forth. Guiding principle, freedom of contract, sanctity of the contract, human rights, and so on and so forth. The law should be, the interpretation should be guided by this principle. I have given some example. I don't think I have the time to go into detail. There was a good case in Fes. Fes is a city in Tunis or Morocco. In the 13th century of AD. That would be what 8th century of Islamic calendar. So the river was polluted, still polluted until today, somehow. The case was brought to the court, trying to ascertain the liabilities of parties who were supposed to put the cost to clean the river. So there are many parties: the manufacturers, the farmers, and the householders, the one who use the water for the day-to-day purposes. And the case was brought to the court, and the court has deliberated very nice way. And I don't want to go into detail, but you can see the sophistication of deliberation by the court of the law on environmental law regarding to water pollution. And if you wanted to know about North Africa fatwa for 500 years, it's a good book published by the government of Morocco, the Ministry of Awqaf, Al-Fatwa Al-Mu'arib and Al-Ma'yar Al-Mu'arib and Fatawa Ahli Afriqiya wal-Andalus for 500 years fatwa, which is why I'm interested, because fatwa reflect the actual cases of society. The jurists, the scholars, people like me, sometimes we just write, we give the opinion, but not necessarily related to the actual cases on the ground. So the fatwa was real, bona fide, and genuine case we can learn from. And I wanted to skip the other two examples unless you wanted to know more. The modern one we wa'ad undertaking, I mentioned this morning that in the forum, wa'ad and English common law, there are two views among the lawyers at the moment. Wa'ad is not enforceable until and unless it has some consideration, and some other group of common law lawyers were saying wa'ad is still enforceable even without any consideration. So this is the debate. But in Islamic law, we have three views. Some would say that wa'ad is not enforceable at all. You are liable under the law religiously, but not under law and administration of justice. You can exclude yourself from any liability if you were to breach any promise. The other point of view, the wa'ad is binding on both parties by some contemporary scholar, because in modern time, we have to make sure the promise is binding on the promisor, on the promisee. The prevailing view in the banking sector, the promise is binding on the promisor, provided the promisee would suffer the loss, would be detrimental to him if the promisor were to breach the promise. So the ratio decidendi, the fact of the case, is something detrimental to the promisee if the promisor were to breach the wa'ad. Practical aspect of Islamic law making in modern world. As I mentioned to you, in modern world we have government, we have nation state at the moment. Okay, when the nation have their own jurisdiction, they tend to put the laws, and the laws in many cases would be in the form of statute for the personal, for the family laws and inheritance, divorce, and so on and so forth. Otherwise, the society can refer to the religious or awqaf department or ministry in many Muslim world. This council or these judges, if the case were to go to the court, would simply make some preference. They may listen to the case. Based on the fact of the case, they may choose one of the view as their decision. If the view has been provided in the statute, they have no option but to apply the law as it is. If it is not provided in the statute, they have to use their ijtihad, and basically the ijtihad will be guided by the precedent, not the judgment, but the views of the jurists, of the scholars in the past. There are many examples. I've skipped the example at the moment. In some jurisdiction, some law have been qualified. In United Arab Emirates, for example, when it comes to family law, it is very much pretty qualified compared to the Saudi Arabia, because they don't believe in codification of the law, for example. In new cases, which require new interpretation, scholars or juries or judges or muftis or Sharia members, Sharia board members of the bank, we have to use some other legal techniques to arrive at the required or desired law that we believe would be the law of God. So it is the process of understanding the whole process to find a law to a particular solution, which we believe, fully believe that this is the law which is desired by the lawgiver, Allah subhanahu Almighty. So we use some techniques, analogy, as you know, juristic preference or equity in under common law, maslahah, and so on and so forth. So very structured and heavy loaded technical techniques to arrive at the law. And interestingly enough, in modern law, in modern application, the analogy would occupy about 80% of the technique to arrive at the law. And many scholars in the past were saying the same thing, because analogy is basically to transfer the law of the past in the Quran, in the tradition, to the modern fact of the life, if they were to share some common ratio decidendi, or if we can apply some obiter dicta to apply another ratio altogether. A practical aspect of Islamic lawmaking in modern world. For all intent and purposes, okay, the exercise of finding the law should be governed by all the time by the Quran and the Sunnah. That's why Islamic law is very, very special, because it based on something which is given and not created, given for Muslims to believe, given by Allah from day one. So there's no need to find the source of law. The source of law was really given from day one. What we have to do is to understand, interpret, refine, reconstruct whatever based on the same raw material, which is the Quran and the Sunnah. To a considerable extent, the same process applied to our day-to-day function as Sharia scholar. We look at the Quran, the Sunnah, and try to look at the classical point of view, and try to choose an opinion we can support the industry, can protect the interests of both parties, the banks and the client, the stakeholders, investor, intermediaries, and so on and so forth. The application of Islamic law in modern Islamic finance, to be brief, nowadays we have the Sharia standard issued by IOF in Bahrain, in jurisdiction like DFSA, in Sudan, Bahrain, perhaps Jordan. They have made a standard that each and every bank, Islamic bank in those countries, they are bound to follow the Sharia standard and the accounting standard issued by IOF. When they record the financial transaction, the recording of financial transaction should be in accordance with IOF standard. Though they may use International Accounting Standard, IAS, but they have to make reference to accounting standard where relevant, or the other way around. They cannot run away from IOF, at the same time they have to be compliant to the IAS where relevant. These standards in other countries are not binding, they become persuasive in character. In Malaysia, in Jordan, in Turkey, for example, in Saudi, even in Dubai, which is not the FSA, they become persuasive. The regulators sometimes interfere and intervene to put some guiding principle for the Sharia scholars to interpret, and in some countries it is governed by the central bank, in some countries it's up to the individual Sharia board in the bank to decide on the law-making process to find the fatwa, the resolution for each and every product to be offloaded and sold to the public. This is interesting again. You might be asking me about the quality, the enforceability of the fatwa issued by a Sharia board member of the bank on other Sharia scholars who are not part of the whole process. So in many documentation we have seen, we have observed, there's a clause saying that this is our opinion, this is our construction of the law as we understood, but before you invest in our fund, in our product, our sukuk, you have the liability and you have the duty to read through and to give your own view on the compliant. If you think this is not compliant, it's your liability. If you think it is compliant and you put your money in the fund, and you can argue in the future before the court, before court of the law, that this is not compliant, because this would take care of the future dispute in the court of the law with regard to the compliant aspect of any product.